Good afternoon, everybody. Let's go ahead and get started with the presentation. So many of you will already know who Boyes Turner is, but for those of you who don't, we are a full service law firm based in the Thames Valley. We provide a range of legal services with a particular focus on the technology and leisure and hospitality sectors. And for those of you who don't know me, my name's Shona. I'm the professional support lawyer here in the Boyes Turner employment team. And my background is as an in-house lawyer. I worked covering the EMEA region, and a very, very long time ago before that, I also started my career in HR. Here at Boyes Turner, we have a large employment team and we deal with all employment law matters. We also have an immigration team and we can provide employment law training for you too. We also have a specialist who deals with data subject access requests, which is the topic we're covering today. And they deal with that on behalf of clients. And we also have a platform that's very useful for gathering data and making the entire process much, much easier for you. So in today's session, I'm planning to talk to you for about the next 30 minutes or so about data subject access requests. We seem to be seeing a lot more requests coming in through to us, through our clients, and given how many of you have registered for today's session, it seems to be a bit of a hot topic at the moment. If you have any questions as we go through, please do drop them into the Q&A box. I won't be able to respond to them on this session, but either me or one of the team will get back to you at the end of the session. So today I'm planning to just go over how to spot a data subject access request, what to do next, carrying out a search, excluding data, and then a quick look at the new Data Use and Access Act 2025, and then a quick look at some takeaways for you as well. So first of all, what is a data subject access request, or DSAR? So individuals have the right to obtain confirmation that their data is being processed and also to access that data, and that's what we call a DSAR. They're entitled to information relating to them, including the purpose it's being processed for, the categories of their personal data held, and along with some rights to object as well. And the idea behind a DSAR is that data subjects can find out how and why their data is being used and to check it's being processed lawfully. Often, though, we do see them being used as fishing expeditions. So an employee or somebody might want to see if there is something that they can use, perhaps if they feel they have a complaint. And I can think of a case where a DSAR was used in order to find out the facts for an employee to bring a claim, and the Employment Tribunal actually extended the time limits for them to allow them to get that information in order to make the claim. Sometimes they are to disrupt you, or perhaps even to get you to add to a settlement agreement, discussions that you're having at the time. And the employee might want to leverage an increased settlement. And often an employee is looking for a smoking gun. So they might think they've been the subject of conversations, and they think they might find that little bit of information that means they might be able to make a claim or prove that they're right. And more often than not, that information just doesn't exist, but employees will still try to look for it. So why is it important that you respond? There are consequences if you don't respond or you don't respond properly. Somebody who's made a DSAR is unlikely to just go away if you don't reply to them. And here you might leave yourself open to victimisation or unfavourable treatment complaints if you don't respond or don't respond properly. And that's a particular risk where you have an employee who is already thinking about making a claim. You could find that you're adding to the cost of any settlement. The Information Commissioner's Office is responsible for managing, as you probably know, any issues with regards to DSARs and complaints, and employees can complain to the Information Commissioner's Office. They are likely to write to you and ask you to comply, and they might also reprimand you if you have done something wrong here. Essentially, that's naming and shaming you. And if you go onto their website, there is actually a section where you can go and look at a list of actions they've taken recently against organisations. Employees could also ask for a court order requesting that you comply with the DSAR they've submitted, and they might also ask for compensation because you haven't complied. So as an example, I can think of an employee that was awarded £2,250 where the organisation hadn't responded appropriately to their DSAR. They hadn't provided all of the documents that they should have done. So it is important that you respond. And if you were to repeatedly ignore or miss requests, the Information Commission Office also has some options available to them. They can come in and they can investigate, and they can also fine. I'm sure you'll have heard about the maximum fines, which are 17.5 million or 4% of global annual turnover, whichever is the highest. And it's unlikely that it would be a fine of that level, but those are just the highline numbers for you. So spotting a DSAR, there isn't a formal set requirement for a DSAR request. So spotting them can be tricky. They can be made verbally or in writing or by social media, although I haven't seen one come in through social media. So if you have, do drop me a note and let me know. I would be interested to find out. And there's no need for the requester to include the term DSAR or subject access request SAR in their request. It just needs to be clear that the individual is asking for their personal data. The Information Commissioner's Office does have some guidance for people making subject access requests, and they do recommend that they use the term DSAR or SAR, but they don't have to. Again, it just needs to be clear that they're asking for their personal data. And we can't ask the data subject to use a particular form or a particular email address to submit that request. Although it is a really good idea to provide that, because somebody who's keen to get their data will generally want to make sure that you've received their request. So if you've got those options available, it's a good way to funnel those requests through to the right place. And just lastly, there's no reason needed. So the requester doesn't have to give you the reason that they're asking for their data. So as you can see, it's really useful to have some training for employees so that these DSARs don't get missed. Often employees will submit a request to their line manager, so line managers need to be aware of what to do if they receive one. And it's important these aren't left on somebody's desk, and think too perhaps about somebody who's left the company and it goes through to their email. Will that be picked up? We had a fairly recent instance where a request was sent through to a general inquiries email, and that email covered the entire of the European region of the company, and it got lost in the system. So it is really important that people who are monitoring communications are aware of DSARs and where to send them if they get one. It might also be really useful to have a form for people to complete. So if they receive a verbal DSAR, then they can note down the important points and also then send that to the right place. So you've had a DSAR, what should you do next? Again, as I mentioned before, this is definitely something Boyes Turner can help you with and make easier for you with a platform and specialist advice. So the first thing you need to do is acknowledge receipt of the DSAR and confirm the date it was received and the date you're due to respond. And ordinarily you need to respond within 1 month of receiving it and without any undue delay. So really you're looking at as soon as possible. And the time for response is calendar months. So for example, if you were to receive the response today, today's the 17th of July, the countdown starts today and the deadline for response is 1 calendar month, which is the 17th of August. But that happens to be a weekend. I think that's a Sunday. So if the date's on a weekend, then you have until the end of the next working day. So if you got a request today, you would be due to respond by the end of day on the 18th of August. So as you can see, the amount of days you have to respond can vary depending on the month or the day that the request is submitted. So it's a good idea to keep a log of DSARs you receive, and also the dates they're due so they don't get missed. You might need to make sure of the identity of the person requesting the information before giving that out. So, for example, if you don't already have an ongoing relationship with them, they're not a current employee, maybe. And if you do need to request that, then you stop the clock on the time limits that I just spoke about. And that clock starts to run again once you receive proof of their identification. And you need to make sure that you request that ID as soon as possible, but definitely within that 1 month time period. Sometimes you might want to ask for clarification about a request. As you know, an employee's life cycle can generate a huge volume of data. So you can go back and ask somebody to narrow the scope of their search. For example, you might say, could you give me a date range, or is there something specific you want to ask about? Often the employee won't want a huge amount of data either. And again, that pauses the time limit, so the clock stops until they come back with that information, or come back and say they're not going to provide it, because we can't force them to do that. If they don't come back at all, you might be able to close the DSAR request down. But in both of those situations, I would suggest that you are getting some advice, because you want to make sure that your request for more information is appropriate. And certainly if you were going to close that down, make sure that that's an appropriate route to take. And just the last point here is make sure you don't delete any data. Once you receive a DSAR in, make sure that everybody involved knows that we have it and they shouldn't delete anything. It is a criminal offence to delete something to avoid producing it under a DSAR. And your data policy, privacy policy, should also contain a data retention schedule, and that schedule would set out how long you keep data for before you delete it from your systems. So it is important to have an up-to-date policy and that deletion schedule. We had a request come in reasonably recently for some CCTV footage that was on a 2-week deletion schedule. So it existed when the DSAR was submitted. But unfortunately, by the time we came to gather the data, it had been deleted under the deletion schedule. So it is hard to justify when data has been deleted after the DSAR has come in. So if you have deletion schedules, it's really important to flag up very quickly that data needs to be retained. And extending the time limit. So if a request is particularly complex, you can extend the time limit for responding to it by up to 2 months. So that would be a 3-month response period in total. If you're going to do that, you need to tell the data subject as soon as possible and not wait until after that initial 30-day, the initial calendar month has expired. And the data subject doesn't need to agree to this. We simply have to tell them. But they can complain, and they might decide to make a complaint to the Information Commissioner's Office, who'd want to see why you had said you needed to extend the time limits. You need to be comfortable sharing your reasons for that extension. So again, it's a good idea to get advice here if you need it. So let's have a look at what might make a request complex. That we have a large amount of information isn't sufficient, unfortunately. It might be able to contribute to something being complex, but just on its own, the fact that there's a lot of data isn't enough to extend time limits. And having to rely on a processor to find the data, again, isn't a reason to make it complex. What you are looking at here is, for example, technical difficulties in retrieving the data. Maybe it's been archived somewhere. Large quantities of sensitive data, so where you have third-party information that you need to avoid disclosing, so you might need to do a lot of redaction, for example, to protect their data, and also the need for specialist legal advice. And this is where it might be relevant to ask a data subject to narrow the scope of their request. And this is something we have lots of experience on, so we're very happy to assist you in assessing whether you have a complex request. There are a few circumstances where you can refuse to comply with the DSAR, but they are very high thresholds. And if you want to use them, you need to tell the data subject as soon as possible and within that calendar month. There might be an exemption that applies. So, for example, if there's a crime and you've passed data to the police, that might qualify for an exemption. The other two here are that the request is manifestly unfounded. So essentially, we're saying here that the request is intended to cause disruption or is prompted by malice. In other words, the data subject is asking for the information because they just want to be difficult. And now that we might think that that's the case isn't enough. And actually, it's probably really unlikely that the data subject is going to submit their request and say, I'm only submitting this request because I want to drive up the settlement sum that we're working on at the moment. So this is actually quite a high threshold to meet. You could also refuse because the request was manifestly excessive, and it would need to be clearly unreasonable here in all of the circumstances. So you'd be looking at various factors like what's been requested. Is it very sensitive? Is this a repeat request? Are there overlapping requests? Which you might get, for example, if an employee is hoping for a smoking gun and they don't get it, they might continue to make requests. And remember, having a large amount of data isn't going to be a reason here. These are both very high thresholds, the manifestly unfounded and the manifestly excessive. So if you are hoping to use one, please do get some specialist advice because you will really want to be able to justify why you're doing that. So once that's all through and you have all of that information, you will need to carry out the search. And again, this is something that our Boyce Turner platform can help with and make much easier for you. You'll know that you need to search through emails and files and hard copy notes, but there are some other things to think about too. For example, WhatsApp messages and things like Slack. I know lots of companies are using Slack at the moment. And you should probably know that their lowest level of license doesn't let you gather information. And if you're using it for business purposes, then you should be the data processor and be able to access that information. So that is something to go and have a look at if you are using Slack or any other communication device like that. And it's also worth thinking about the fact that people who are using WhatsApp and text messages and so on can often feel more relaxed when they're using them, and communication can sometimes get a bit more informal than when they're using formal emails. So it's useful to remind employees about the standards of conduct you expect of them when they're using these channels, and to really think about having that set out in your policies around discrimination and harassment, as well as your grievance and disciplinary policies. And probably a good idea as well to put in place policies around WhatsApp, for example. It's also worth thinking about whether employees' personal devices are being used for work conversations, which might bring them into the scope of a search. If it's personal communications, then it probably isn't disclosable, but just be aware if they are discussing work matters, even if that's in violation of your policies, it might be disclosable. So it would be a good idea to have a look at your IT policies and your bring your own device to work policies, to make sure that they are providing you with the control over the data that you need. And again, reminding people about their communication through these channels. And then just lastly here, data we provide has to relate to the individual. So, for example, if you've used an employee's initials rather than their name in a communication, that's something that you would still need to disclose. And just recently, there was some case law around Mike Ashley, who I'm sure you'll know is of Sports Direct fame. And he had asked HMRC for some information, some personal information around some properties that he owned. He'd had a tax bill and he wanted to dispute that. And HMRC had gone back to him and said, no, we're not disclosing this information under the DSAR. Because these are properties, they're not identifiable people. and he complained. The court said that the property values and the information about the properties were related to his tax implications, and so they were related to him, and that information should have been disclosed on the DSAR. So it can be quite a wide net as to what information you're going to need to capture here. And actually, that particular case also highlighted the fact that if you are a company with a lot of, your group company with a lot of separate entities, an employee doesn't necessarily have to make a DSAR to each and every entity. They can make one DSAR, and you are expected to go and gather that data for them. So excluding data. So when we get through the data and get everything back, there are some things that we are likely to want to exclude and not provide to the employees. So the first one here is legal privilege. So that's any communication for the purpose of legal advice can be excluded, and that is, it needs to be for the purpose of legal advice. It's not just something you've copied your lawyer into. When I was in-house, I would often get copied into all sorts of emails about HR matters, which wouldn't necessarily mean that they attracted legal privilege. It really, really didn't help my inbox either. So that's something you need to assess. References might be exempt if they're given in confidence. But if you want to do this, I would very much recommend that confidentiality is set out in your recruitment policies and also your data privacy policies and notices. Otherwise, you might not be able to use that. And you might be able to exclude as well management forecasting information. So, for example, you might be talking about some redundancies, and disclosing that information would let people know they're at risk before consultation has started. This is all very context specific. So again, I would very much recommend you get advice about excluding this. And third-party data, we don't necessarily have to provide information where that would involve disclosing information about another individual from which they could be identified. And there are some exceptions. So unless you have consent from that individual, or it's reasonable to comply with the request without the consent of that third party. It is really about balancing the rights of different individuals here under data protection. You need to think about what's reasonable, and it is a delicate balancing act and something that needs to be carefully considered. I mean, really here you need somebody who's trained in redacting and to have a good review process. In that Mike Ashley case that I mentioned a couple of minutes ago, the court was extremely critical of how heavily documents had been redacted to protect information, and the court actually said that it was so heavily redacted that it had made the information unintelligible. So you really do need to think about what you're redacting and the process that you're using. Again, I'd recommend you get some advice here. And then just the last thing on the list here, data that's deleted under your data deletion schedule on your data retention policy. So if you have a clear schedule of deletions and you've complied with that, you obviously don't need to provide data that you've deleted in accordance with that policy. Well, you won't be able to because it has been deleted. What if there's an ongoing process? So this is a really common question for everybody. So perhaps you've got an ongoing grievance or disciplinary process, and then suddenly a DSAR comes in while that's ongoing. The important thing to note here is that they are two separate processes. So you do have to respond to that DSAR. You might be able to exclude some data. So for example, legal advice. And it's probably worth considering whether that request might then be complex. I think at this point it's a really good idea to engage your advisors and to get some specialist advice here. Remember, you have a duty not to disclose third-party data, so it's important to send out information you shouldn't. So I'm thinking perhaps about witness statements and so on. It is a really very delicate balancing act because a witness statement, you are quite likely to be able to identify the witness from that document. and they would likely have an expectation of confidentiality as well, provided you've included that in your grievance and disciplinary policies. So if you haven't, I would recommend going and reviewing those policies and make sure that's in there. Again, it is a very delicate balancing act, so I would definitely recommend you get some advice here. So what happens when you send out the data? Again, this is something we in our platform can definitely help with. So the information you provide has to be intelligible, and you might well need to explain what the documents you are providing are about, and how data about the requester is used. So a good data privacy policy is really helpful here, because you can attach that, and particularly if you have deleted data in accordance with your data deletion schedule, it's great to be able to attach that. So again, if yours hasn't been reviewed for a while, I'd really recommend doing that. Often a data privacy policy will be more focused on customer data than employee data. So I would definitely recommend a review of that if you haven't done it recently. As I mentioned at the beginning, often employees are hoping to find that smoking gun, and often they simply don't get it when they get the documents back. If they don't, they may well decide to complain that you haven't given them all of the information. So it is really good to be able to justify what you've provided and to be comfortable explaining that perhaps that information just doesn't exist, or the information that you have provided. And actually to be able to provide that information to the Information Commissioner's Office or to a court if necessary. But it's also really important to watch your communication channels, because if the employee hasn't received that smoking gun, they may well make another subject access request. So do keep an eye on that. Just quickly, the Data Use and Access Act 2025 came into force on the 19th of June this year. It doesn't replace the Data Protection Act or the GDPR requirements, but it does make a few amendments. Its main impact on the DSAR process, though, is that it becomes less onerous on employers. So good news. And now you only have to make reasonable and proportionate searches when somebody asks you for their information, so on a DSAR. Obviously, you'll need to think really carefully about what is reasonable and proportionate in the circumstances, and we will probably see more guidance from the Information Commissioner's Office here. So do look out for that, and do think about that in each of the circumstances. Again, get advice if you're not sure. Other than this, it mainly codifies the other aspects of DSARs, so it sets out the time limits that we already know about. So you don't really need to do anything here, although I would really recommend that you update your policies and documents to reflect the fact that you'll carry out that reasonable and proportionate search in line with the requirements of the new Act. And the other thing to look out for here is that the Information Commissioner's Office will be renamed the Information Commission. That hasn't happened yet. We'll need some implementing regulations for that. Unfortunately, that does mean you will probably have to change the references in your documents and your privacy notices and policies to reflect that change. So let's have a look at some takeaways. So I would very much recommend that you review your data privacy and data retention policies. A process for dealing with DSARs is also really useful. That way anyone who picks one up knows what it is and can pass it on to the correct person, and the information that we're providing is consistent. And DSAR awareness training, make sure that people know how to spot one. It's also a good idea to look at some of your other policies too, around IT usage, perhaps WhatsApp policy, your discrimination and harassment policies and disciplinary and grievance policies, as I mentioned earlier, and also to remind employees about their written communications and the standards of conduct that they should have. They shouldn't write down anything they might not want the person they're talking about to see. And if you need any help with any of these policies, or you have DSAR requests that you'd like help with, please do get in touch. As I say, we have expertise and also a platform to help with DSAR. So please do reach out to us. We would be very happy to assist you. As I mentioned, unfortunately, I can't answer your questions now, and we are almost out of time. But if you've dropped anything into the Q&A box, then we will get back to you. If you haven't had a chance to do that, please do feel free to reach out to me. My email is there, so spipon@boysturner.com or employment@boysturner.com, and either me or one of the team will get back to you. And if you do have a DSAR we can assist with, please do drop that to the employment email there. I work part-time, so that would be the best address. Okay. Thank you very much for your time today. Please do get in touch if we can help you further.